The number 51.
May it please the Lord. Well, this is an intra-court appeal. It is otherwise ready for disposal, hearing. Well, the issue relates to the filling up the post of the headmaster of the school on in-charge basis. Very temporary arrangement. In-charge headmaster was appointed. My client was appointed as the in-charge headmaster. That has been put to challenge by the private respondent 4. And the learned single judge interfered with, holding first that the seniority was decided in my favor, although that was not put to challenge. The seniority issue was settled. That was not.
Who is appearing for respondent number 5?
Lordship, I am appealing.
Ready for disposal?
Yes, Lordship. Otherwise, Lordship, the rule says, Lordship, or even for insertship or for regular appointment, the requirement of the rule is that 10 years of minimum qualifying service as a graduate teacher, number 1. Secondly, candidates should possess the PTBA degree. Here in the instant case, both the petitioner as well as the respondent, they are not fulfilled both the criteria. So accordingly, this honorable court directed to make a fresh determination of the seniority. Now, while determining the seniority by order dated 2017-2021, they hold that the appellant is the senior most teacher. But here, what happened? The school in question is provincialized with effect from 1/1/2013. So therefore, they became the government employee with effect from 1/1/2013. And they born in the cadre of graduate teacher with effect from 1/1/2013. But the rule of 24/7 says, if the date of joining of the cadre is same, then the date of birth is to be accounted. Now, by considering the date of birth, I am the senior most teacher, Lordship. That is why the honorable single judge directed or hold that the petitioner is the senior most teacher. So accordingly, direction is given to the director of secondary to for determination of fresh seniority list, number 1. Secondly, on the basis of the seniority, they should depute the teachers for pursuing BA degree. Until the arrangement, Lordship, is made, the inspector of school is directed to hold the charge. So I think my submission, Lordship, that there is no infirmity against this order, Lordship, because the rule is settled, rule 24/7. It is quoted. Lordship, may kindly see page 59. Page 59 for a moment, Lord.
Should I place my case? This is my appeal.
Page 59, Lordship.
I'm coming to it, my lord.
Lordship,
The
down
whole
below.
issue, my lord, my response submission, the learned single just misconstrued the entire. Firstly, this is a temporary arrangement. Fact remains that as per the qualification required to hold the post of or to get promotion to the post of headmaster, none of us possess it. The requirement is that B.Ed degree is a must. None of us possess it. Now, the authority appointed me as the in-charge headmaster on the basis of seniority. That seniority issue was settled by the government on the appeal made by him. And the seniority issue was not taken in challenge, directly telling that order, that this order passed by the authority fixing seniority, my position below me, he never put it to challenge. Indirectly, he came in challenging only the appointment, my appointment as in charge headmaster. Therefore, the first ground is, what is the substantial right of the petitioner which has been infringed? When prima facie, the seniority has been fixed and my position is above her. On the basis of seniority only, because there is none qualified in the school to hold the post on senior on regular basis.
Substantial basis.
Substantial basis. Therefore, it is a temporary arrangement. I was given until post is filled up regularly on the basis of seniority. Now, how the question has been considered, Lordship will come to it. I will take your Lordships to the impugn order. Firstly, before that, Lordship may like to peruse at page 55. Our date of joining, page 55, Ballot. This was our initial date of, well, firstly, Lordship will kindly,
Can we have a
No.
look at the prayer and the petition, please?
yes. Prayer and the read petition, Lordship will find.
Page 34.
34 of the, Malad,
That is that.
paper book.
Prayers gradation list, that is a prayer.
Yes,
They have challenged the seniority list.
impugned order dated so and so. This is firstly, Malad. Firstly, that is 27/10/2021 is the appointment order to the post of headmaster as in charge basis.
Second prayer takes
Then
care of
second
the
prayer-
petition.
Publish a fresh gradation list.
Yes, that is the seniority list.
The seniority list was published on the basis of an order issued after adjudicating his appeal. That order ought to have been put into challenge. What is the ground on which that appeal was decided, fixing my seniority above her?
Have you placed the order on record?
That has not come.
Even you have not placed it on.
No,
This is an oral
I am
submission
not given that.
that there was any such order.
Kindly see at page, it is mentioned there. In the order to put the GP appointment order. Yes, at page 49. Page 49, that was the impugned order. Here, it finds a mention. Lordship got it, my lord, page 49. Consequent, I am placing it. Consequent upon demise of so-and-so, headmaster of Rampur Salaipatar Sahad Ali High School, district so-and-so, and pending of claim of seniority raised by Mafida Khatun, the respondent.
Pending
Assistant,
claim of seniority. When
Sorry?
was it decided?
yes, second prayer. It is coming, my lord. So-and-so, the inspector of school was allowed to act as in charge headmaster of the school, Vide office number so-and-so, dated 22/2021. Now, then
When has
see,
it been decided?
now government Vide letter number so-and-so dated 21/10/22 was declared Wazuddin, me, Hindi teacher of the so-so school, as senior to Bopida Khatun, assistant teacher of the same school. So this was the order 21/10/2021. And then it says, accordingly, in pursuance of the government letter dated Sasan-Sas 21/10/2021, and until further order, Wazuddin, BA, Hindi teacher of Rampur Salapata Sahad Ali High School, District Nagaon, is allowed to hold the charge of headmaster in charge. The same school, along with financial power to draw and disburse the salary, etc., of the staff of the school, Vice Inspector of School, Nagaon, relieved. That is my order.
Rule. If the date of- then of the- the order. In short, that is the order. That is not clear.
This order of 27th October refers to some determination, but where is the order determining the interstate seniority?
That was never placed. That was not.
No, but
brought on
you
record.
have that order.
I do not have. We do not have that order.
Is there any such order?
Lordship, that order is not with me. That
That was
21
not challenged.
Yes.
How can you question the seniority of this man?
Lordship, this is the decision taken by the government, Lordship. So in view of that 21/10/2021,
You have a right to represent against the determination of seniority. If that is illegal, there is a challenge. It is required of you to challenge it as per law. That was never challenged. It may be wrong.
Yes.
That's a different thing. But without the determination of seniority being challenged in the writ petition or otherwise, how can we intervene in that?
if you look at the day, came to a conclusion that the petitioner, the appellant is the senior most teacher. But here, Lordship, by counting the date of
We
joining,
don't know, sir, what is the consideration by which the seniority list was decided. That should have been brought on record. If you're not satisfied, you have to challenge it.
But
Yeah.
I am told that there is an Assam services appellate tribunal. Like
Administrative tribunal is there.
administrative tribunal. So
Administrative-
if at all you are agreed by the seniority list, you have to challenge that before the tribunal.
no, that seniority list Lordship never published, Lordship. Lordship kindly
Sir,
see.
that order is referred to in your impugn order.
Yes.
You should have got a copy. What prevented you from doing so?
Not the authority, Lordship, they can produce that particular order.
Why
But
should,
the
we,
fact,
why should we ask them to collect evidence for you? It is your client who is aggrieved by the seniority list. You can simply seek it under RTI if it is not provided otherwise.
True.
Yes. Otherwise also, sir, the order is depriving you, both of you, from the post. So why is it required to be challenged? The order is justified. The
No,
inspector
Malad, there lies the question, Malad. Since was already a finding recorded by
we
the
can,
appropriate
we
authority.
can only observe that the finding regarding the seniority may be ignored, but otherwise the remaining part of the order is justified
Now,
because you are not qualified to hold.
no, Malad, then in that case, as because my response submission would be, then who will hold the post? Either one
The
should be
inspector,
appointed.
inspector holds it. Let the government
No,
decide.
Malad, then
who is to
whether,
assign the post of headmaster.
Malad, so until
The government does not want an unqualified person
true,
to
Malad.
hold the post of headmaster.
Technically, yes.
Yes.
Technically, yes. But Lordship will see the other part. So far the interest of the public institution is concerned, that will not be served by the technicality.
So
That
they
is my
take
response.
care of the things. They will appoint a duly qualified person as headmaster.
As early as possible. If they do it, it is good. But till then, someone who is responsible in the school, and I being the senior most person declared as such.
But both of you don't meet the
But
eligibility.
true, well,
norm.
therefore I am not claiming it on regular basis. I was given, the government has thought it in their wisdom
Other
that
than
someone in the
simple
school.
status, do you have any, other than simple status, do you have any monetary advantage? Because of
Nothing. But then I am interested in the school management because this is my school. Someone from outside coming
Government
temporarily.
Mr. Government Council, take instructions, how long will it take for you to appoint a qualified person as the headmaster?
Part of the to take the stuff that it and all. Some these people get on the pure. Otherwise, that also is prior to appointing him as the in charge, the inspector was still holding the,
Yes.
and it was the order to the that the inspector now continues to hold the. There should be no difficulty. Because the physical power is held by the while the academic matters are being kept to one of the senior most person.
No, Malad.
The physical matters that
Mr. Majumdar, but is the inter-se seniority between the appellant and the private respondent settled? I don't think, we don't think. No, the learned civil judges said to reconsider this.
So we can say that the inspector of school holds the power, holds the charge of the master with powers under 49C run the daily affair. Academic matters are looked after by either the inspector or the sergeant. That is how. The routine is
That's right. But
No,
there is-
Malad, let my largest friend
just
look
a
into
minute.
the order.
Just a minute. There is already a order of this court, number of orders, where it has been laid down that even for a temporary appointment, the government will have to follow the norms of seniority.
Yes.
As on date, there is no clarity as to between both of you who is the senior. Moreover, neither of you meet
not
the
qualified. Same
qualification.
judgment by law says that the most qualified person who has to be given other than cannot be given the charge.
Where is that judgment?
The Jagannath Pegumelo, the
Milord, I will come to it later on, but let the facts be clear first. Let the facts be clear first.
At 2 p.m.
Division bench to another. Division bench to correct.
Item number 51 to continue.
Okay, 14. The judgment I have, the judgment I have given, my lord, the 42, where it is.
I will come to this judgment, my lord, in my school submission little later. Before that, Lordship will kindly find out what are the background facts for how I was appointed. That your Lordship will see. That decision is there. I will address your Lordship on that also. Because every case has to be decided on its own fact. So for the principle of law is concerned, yes, it is there. Now,
We'll speak out our mind then. The best we can do is
Yes.
that we can make an observation that the findings in the June order regarding seniority, they will be ignored and the parties will be left to approach the appropriate forum for settling that issue. Otherwise, the direction is perfectly in accordance with law.
my lord, before that, I am grateful to your Lordship for expressing the mind. But before that, probably I will have to point out few things for little more time. And then Lordship I will request your Lordship to consider it, whether your Lordship's view needs to be reconsidered.
Definitely,
Yeah.
we are open
I am
till the
grateful.
last moment.
I am grateful, my lord. My lord, so far, the basic fact that we do not have the qualification, that is true. But seniority has been decided in my favor. That is as on date. That is decided.
Apparently erroneously.
No,
There's an
my lord, that we do
apparent
not know. That we do not know because we have that order was not put to challenge.
Criterion is settled that where there are two persons who join service on the same day, the seniority has to be decided with reference to the date of birth.
Well, provided it is on the same date. Here, that is not applicable. That is my case, my lord. Law speaks otherwise. That is why my ground is that 24/7 has not been properly appreciated. That is why I will come to it a little later. Lordship will kindly see up page 47. It is the inspector of schools who requested the authority to appoint one of the senior teachers of the school as in charge principal headmaster. On that request, because he was holding the search, he found it difficult to manage from a distance of 19-20 kilometers away from the school. At page 47.
Sir, come to page 45.
45 is the seniority list prepared. It was forwarded to the government. That was put to challenge. It was taken on appeal before the government. Government has ultimately decided
Who says so, sir?
that order says,
Show that this was challenged in appeal.
well, that was in order. That has been mentioned in the order itself. That is what I'm
all
saying.
In the realm of uncertainty. We don't even know that there is an appeal.
But that is why my case is, well, it ought to have been put to challenge by them first. Because when the seniority was settled,
We are seized of the situation that two persons who join service on the same day.
no, my lord, we are not on the same day. Here,
How do you dispute this order in Annexure 4, please?
Annexure
Have you
4,
find any counter affidavit against that?
Annexure 4, this is, my lord, here it is date of receiving graduate skill and date of joining is different. At page 45, Lordship has referred to. Kindly see. My date is 18/10/93. Towards right hand column, my lord, second from right. And her date of joining 3/10/94. 3/10/94. And here in such a case, because there are two things, my lord. Pre-provincialized schools and recruitment after provincialization. Then two things comes. Here we were provincialized on the basis of our original seniority in the school. We carry that seniority. 24/7 rules, it speaks about the post recruitments made after provincialization. Then only the question of joining. Here, that is why I pointed out initially, my lord, that in that order, our same thing, lordship will find at page 55 also. 55. This was our appointment approved by the inspector of schools initially when the school was under deficit granting stage, where our date of appointment has been shown.
Is the government letter
21st
21st of October 2021?
No, but no
It's
one
not
got
on
it on record.
Sorry, Malu.
This is their 849.
That order has not been brought on record. That was not put to
What is
challenge.
there in that letter?
Sorry?
Was he? And
59. On the basis, sorry.
this that we join maybe
Mahanta
My lord,
and Mr. Deka, there are two aspects here. One is that the seniority, inter seniority between your client and the appellant. Apparently, it was decided by the order dated 21/10/2021.
Yes.
That's what we find the mentioned in kind order as well as in the judgment of the learned Singhal.
exactly.
This 21/10/2021 is apparently declared that the appellant was senior.
Yes.
And we find that there are some materials to even support such a conclusion. The date of joining of appellant was 93, your client was 94.
With that,
Just visible. Now, you have not challenged this order, 21/10/2021. Correct.
Correct.
So therefore, why should we go into the question or any court go into the question of the seniority dispute between both the parties? This is one.
not even a player.
This is not the issue here. Secondly, both of you are not qualified to hold it. Therefore, in view of this judgment, the practice, division benches that unless you are qualified, forget regular, even in charge.
Yes.
So therefore, what is wrong with giving the inspector the charge of the
I am not against the inspector.
My lord,
I am against. I am agreeable, Lordship. I am
you
agreeable.
want that I should be,
Yes, I am
I should be
agreeable.
removed.
Lordship, so far,
Inspector should be
Best,
brought in.
best we can do for you is that we expunge these observations regarding seniority which have been made in impugn order and then allow the things to proceed accordingly
My lord,
so that your seniority is maintained
yes,
as per 21/10/2000.
exactly. I'm grateful, my lord. Only thing lordship will kindly take care of. My anxiety is the inspector himself expressed his view that
We are
we
not bothered.
want
We are not
someone
bothered.
else.
We are not bothered.
Page
He has
47.
discharged his duties as enjoined by law. So if he fails to do so,
Hello,
there will be
hello,
another inspector to take his place.
My lord, that of
We
course,
will not allow, in view of this division bench judgment, your
Lord.
clients, neither your client nor the respondent can be allowed to hold the post.
Lord, at the same time, judicial pronouncements are also there. Lordship is aware that to meet certain situations, stopgap arrangement, those rules are not strictly
Exigencies
applied.
of
That is why
so required.
exigency request. Now, kindly see, my lord, the inspector of schools, he stays far away. That is why he has written that someone of the school should be given the
So see,
charge.
fiscal arrangement, the inspector will take care. Academic arrangements,
Now, my lord, here in this order, fiscal arrangement has also been made. I have been allowed to
That we will not allow.
financial
Because
power to draw and
You are not
disburse.
qualified. No. You
That
can't
is
be
there.
drawing authority.
My lord, that of course, it is the wisdom of the
What
authority.
is the anxiety for your client to be declared as the drawing authority
No,
without
my lord,
holding the qualification?
I did not ask for, the authority has given me that. I am only coming before your lordship.
That is apparently.
It is the
illegal
wisdom of the
taking
government.
judgment.
It is the wisdom of the government. Government decided. Now, government has not said that we have wrongly decided. Government has not said that. Government has not disputed it. That's who we made it. We made it at the request of the inspector of schools who expressed his
Any
inability.
order passed in ignorance of law as laid down by this court
My lord,
will be held to be invalid.
my lord, under certain exigencies, situations, the authority is to run the show. And in the best interest of the institution, they have to decide. My lord, my interest is the school.
There is a MC for this school.
MC is there. I act under them only. Well, the school has to be maintained, my lord. There is serious situations in the school. Inspector remains 20 kilometers away. He cannot oversee the thing. That is why he wrote back.
Still. There was anyone was
Mr. Majumdar, what is the solution to this? There is a division bench order.
My lord.
Says even for in-charge headmaster, one has to meet the eligibility.
Yes.
Now, do you have any other teacher in the school?
My lord, not,
No.
in that school, my lord, the list does not show anybody else is there, my lord. Now, in this case, my lord, the regular selection is held now at the district level. So on
But as you said, that everything is stuck up in
my lord, not
litigation.
not for all the districts, my lord. Most of the districts are under
So
litigation.
that is the norm across the country.
That's
No selection process goes through without being scrutinized by the High Court, as if we are the recruiting authority.
it is
No selection. Nowadays, district-wise selection, district-wise transfer and appointment is made.
even on the case immediately after this, my lord, the rules are under challenge.
So as the departmental council, what is your suggestion?
My lord, let the inspector of school hold it for now.
But as land council says,
My lord,
inspector is posted 20 kilometers away.
my lord,
How does he supervise
Yeah,
effectively?
exactly.
my lord, in most of the schools where these kind of disputes are there, the inspector holds the financial part.
Hmm.
The rest, he gets advice from the school managing committee as well from lordship. Anything goes wrong, it is an immediate visit, madam. And it is not only the inspector of school who is authorized to do so. They are the ADCs are empowered.
My lord, inspector of school is in charge of so many schools.
Sir, how do
It is
you
on
get out of
paper.
this judgment? Either you satisfy us that this has to be referred to a larger bench.
My lord,
Have you read this judgment?
my
Please
lord,
go through.
yes, my lord.
Ask the-
Huh?
There is hardly any
Oh, yeah. I'm,
leeway in this judgment.
my lord, here, I am here, all aspects were not considered in my report
So
submission.
then we would have to refer the controversy
That
to a
should be
larger bench.
in such situation, because so far, a situation of this nature is concerned. How to manage? Fact remains, my lord.
There is a stopgap arrangement The
Stop
inspector
the
will take
president.
care of things.
One ad hoc cannot be replaced by another ad hoc. And here, kindly see the practical aspect. Well, otherwise, I have nothing to say. The authority itself decided that the school should be, and in fact, my lord, if a person, the senior most one in the school, if he can be entrusted, he will definitely take most. And
The order was- Can you point out any instance of any discrepancy after the direction given by the secretary in the performance of duties by the inspector?
my lord, yes, my lord, in my response submission, in here, firstly, the learned single just committed the wrong because it went totally on.
Forget about that seniority part, sir.
That
We'll make the
that was
necessary
the
observation.
that was
We'll
the
make the
influence.
necessary observation.
Yes,
So far as your apprehension that
yes,
the inspector would not be able to discharge the duties as required,
yes.
whether there is any such incident to suggest that he is not able to
My lord,
perform the duties properly.
his inspector's letter at page 47, that itself is suggestive of the fact that he is not in a position to do it.
Then they will be required to post
No, he was,
a more efficient person on the
my lord,
post of the
my
inspector.
lord, if there is someone, I cannot oppose to it. I cannot oppose to it. But when the inspector himself
So
says,
he simply say that you are required to post someone. He doesn't
yes,
say that I am not in a position.
no, at that time he was holding the post.
No, it is the duty of the inspector
was-
of school lordship. Once
He
the
was
person-
holding the post that time, as has been submitted by the London State
He
Council.
simply presents the situation to the concerned authority saying that you are required to post a headmaster.
Yes,
That's all. He
true, my
doesn't
lord,
say
that is,
I'll not
what
be
is
able
the,
to- I'll not be able to do the work
My
in
lord,
a
in-
stopgap arrangement.
those words are specific terms not there. But otherwise, he was holding the post. Why would have he
So
written?
we will simply make an observation that the findings so far as seniority are concerned,
Yes,
they will be expunged. Otherwise, they understand.
my lord, my response submission is, my lord, to that extent, only my anxiety lordship will can take into account. When the inspector himself says that someone is required to be
Your
appointed.
letter does not take you anywhere. Thank you. Dispose of.
So may I submit what you like? With regard to page 45, for one moment.
Lordship,
Page
may, just a
45.
minute. My lordship
No,
may
that
do,
seniority list was not incorrect.
No,
yes,
We are not making
what I am
any
submitting.
observation at all.
lordship
On the
may,
contrary, if you take our observation, date of joining of the appellant is earlier.
lordship may kindly mention one thing, if lordship finds it proper. Let the school be managed by someone, the senior most one in the school. Financial power can be handled by the
Still, that's
inspector
not
of school.
determined
That
who
is
is senior.
what the council is saying.
Yes, that can be done, my
That is
lord.
determined, sir. You have not challenged it.
No, my lord. I have been
No,
given the power
he
now.
says that seniority has not been determined.
Ah,
He is
yes.
wrong in that.
He is wrong. He is wrong.
He is
Therefore, I
absolutely
say, my lord, the inspector of schools wanted only the senior most someone in the school.
Let the inspector decide how the academic things are to be carried forward. We'll leave him at liberty, but financial powers will be exercised by him.
Well, that lordship may make clear, but I have no objection to this. But I wanted the administration in the school should not. Administration in the school should not suffer. That is my anxiety, my lord. Because students are there, everything will go helter-skelter there.
Very well.
I'm deeply
It has
grateful.
created a logjam.
Yes, that is happening, my lord. There are instances.
Lordship, liberty may also be granted to me, Lordship, to challenge this particular order, Lord. 2110 to
It is, we have not taken away your right.
that
There is a
liberty.
tribunal constituted for that.
No,
purpose.
it should be before the director
Find
because,
that
because the rule says
the rule of statutory remedy being followed is being flouted right, left, and center in this court. At least we will not allow that. There is a statutory remedy, you have to approach that.
Order, the principles of order to rule to might come in your way, mistake. You have not taken that. You are the petitioner.
Yes. Deeply obliged.
Letter number 52.